Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seesaw. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seesaw.
Hi, everybody, and welcome to the February 2026 edition of the Third Fridays podcast. Happy Valentine's Day out there to everyone. This is episode 101, which is interesting for a few reasons. Episode 100 was last month, and we had a few of our more experienced attorneys at the firm talk about where they were when episode 1 premiered all the way back in 2016. The idea of 5 different careers from multiple different places in life, geography, industry, coming together to really find something that they can enjoy and be a part of here at Lois Law Firm was a very good conversation topic for our celebratory 100th episode last month. So check that out if you haven't gotten a chance to. Episode 101 is going to talk about some process, some regulation, some application of rules and law to New York workers' compensation. And it makes sense because, like when you say like 101, right, you're trying to think of the basics and the foundation of what we're trying to do in any type of law. But we try to use this podcast more as like a 201 level. Like what are like the heavier topics, the more in-depth discussions that need to be had regarding the trends in our industry. And one just came out a few weeks ago, not that old yet. And so I thought that our 2 guests here today could provide their insights as to what's going on. So my first guest here is Noah Pollack. Noah, welcome back to the show. You are one of our subject matter experts on medical benefits. So I suppose you'll have a lot of factoids as to why these new proposed regulations will kind of affect our clients. But welcome to the show.
Thank you very much. Good to be here, Christian. Always like it on the Third Friday podcast.
And my second guest, Tomer Lehr, you were one of our guest attorneys on the podcast where we were first starting to see the power of Lasley. Lasley, the Court of Appeals case that implemented, or not really implemented, but gave power to Regulation 300.10c, and we were able to really use that as kind of like a name drop, like a mic drop to judges at the trial level to really force them to uphold the law. So welcome back to the show. Okay. And
Christian, thank you.
Yeah. Okay.
It's going in and out. I'm sorry.
No, we got you. All right. Let's talk about Lasley and 300.10c just before we get to the proposed regulations, right? So Lasley didn't invent new law. It just really gave 300.10c some power. So maybe, Tomer, we'll start with you, right? What is the impact of Lasley? What is the impact of 310C as a regulation for employers and carriers in our industry?
Yeah. 310C is the statute that allows carriers and employers the absolute right to cross-examine a provider without necessarily having contradicting medicals. Something that we've always heard about, something we always got pushback from between, the judges and claimants counsel was, no, you can't just ask for cross without an IME in the board file. If you don't have a medical opinion of your own, you can't just willy-nilly ask for cross. But 310C requires a referee to adjourn the matter to allow the parties to develop medical testimony when it's requested. So that's existed for long before Lasley came into play. But then we got Lasley, third department claim case that made it so in a much more, I guess, just another useful factor, another way that we can kind of push for depositions when we don't really have much to rely on even. So, using Lasley, just asking for cross-examination when we have PFME in the board file, but we don't have an IME, or if there is a temp total running, requesting cross of those doctors that are finding temp total without necessarily having our own opinion on degree of disability. It's been something that I use frequently when I don't have too much in my quiver, I think, as Greg likes to say. Yeah, I think it's been a really useful case that most practitioners on the defense have been using, and frustrating a lot of claimants, attorneys, and judges throughout the process.
And so when we talk about using it, right, Tomer, did you see a difference in just citing the case name from the Court of Appeals versus not citing the case name before it happened? Any difference in the judge's reactions based on the case?
I think the judges were definitely, for the most part, familiar with it. Even some of the more claimant-friendly ones would, credit the third department case. Still, claimants' counsel would definitely push back. But when you drop the phrase pursuant to Lasley versus Wegmans, everyone kind of knows where you're going. And it's generally understood that depositions are going to take place, and it's an absolute right. And there's nothing that a judge can do, because they'll get appealed, and we'll be back to where we were 8 months later.
Yeah, if that.
Not more.
Right. I mean, what's crazy is that the statute has been the statute. The
Right.
language of the statute didn't change. It just took taking it up to the third department and then the Court of Appeals, an actual Court of Appeals, to say, hey, the statute says you shall grant the adjournment. You must allow cross-examination. I think that makes a lot of sense outside of the statute, that cross-examination, as far as due process rights in the American jurisprudential system, is foundational. It's like, you don't just take it for granted what somebody puts in a report, what somebody says. You give the opponent, the adversary, a chance to cross-examine them to impeach credibility, right? And you brought up the primary instance where we would raise this issue. And again, it's crazy that Lasley is a 2023 case. It's very recent, right? Where we've been asking for cross-examination for years and years, and the statute's been around for decades, the regulation. You have claimants, doctors that are invariably producing reports that are giving total disability, 100% total disability. And we know that that's just not the case. For somebody to be totally disabled nowadays, temporarily totally disabled, they cannot do anything, part-time, sedentary, accommodation work, anything at all, is sort of absurd. And to give the benefit,
not even sort of, it is
absurd.
It's like
and to give the benefit of the doubt to the tremendous prejudice and detriment of the carrier and employer, who are paying very high rates. The rates continue to increase. They're paying $1,000, $1,100, $1,200 a week now, based on a simple phrase, a claimant temporarily totally disabled, without any justification whatsoever. You see, just from a common sense cross-examination due process perspective, that statute, that regulation makes a lot of sense. And we shouldn't have needed the Court of Appeals to say, hey, the carrier should be allowed to do this. So we would bring it up. Judges, I think part of it is judges don't want to do anything. Judges just want things to be simple, and judges want it to be a case where it's like, oh, you know what, go get your IME, then we can fight it out. But without that, I don't really want to
Why do something today what we could do tomorrow?
Yeah, 100%. They don't want to actually judge. Like, they're judges, they don't want to judge. It's like, okay, if you don't want to do that, it's funny about the proposed change. It's not just, the proposed change isn't saying that you're not allowed to do cross-examination, okay? It's saying they're going to give the judges discretion whether to grant it or not. But what comes with that, if you read what the board has said about it, they also want judges to be able to justify why they do not or do grant the request for cross-examination. So you know what? If a judge is going to sit there and evaluate the medical evidence that's before us, that's set before us in the case, and explain why, okay, that's one thing. But we would never have judges do that, because what you get are reports where a doctor is giving 100% total disability, and then they're not articulating why. They're not giving any justification whatsoever. There's certain hallmarks, criteria for total disability that are not being laid out, that are in the treatment guidelines, that are in the case law, and they're not doing that either. So really, okay, if the board wants to change the rule, then they better hold the judges to the standard here. They better hold the judges to this directive that, okay, you don't want to grant cross-examination. Tell me why exactly this report is sufficient here. Why is this blanket assessment of a disability sufficient? And you know what's going to happen? when the judges don't do that or don't do that to the way we want them to or satisfactorily, we're going to appeal and we're going to take it up.
Yeah.
So I think there's going to be that. There's going to be appeal of applying the discretion rule, right? Where it's going to be difficult because once you put in discretion, it's going to be hard to overturn. It's like the judges can do what they want. But also it's going to go back to the Court of Appeals because it's going to become a due process issue. It's not just going to be about, okay, they have the statute. The reason they have the statute initially is because it's a due process right to cross-examine. So now they want to change the statute, so we're going to get into the constitutionality of changing the statute, not allowing carriers the right to cross-examine. And so then we're going to get the Court of Appeals not interpreting a statute as far as the language is concerned. We're going to have the Court of Appeals determining whether that's a violation of due process.
And just, and
it's going to go up.
It's funny because, well, I loved all of that. And I don't know if you were feeling this way, Tomer, as you were hearing Noah go off on this proposed reg. Like, Noah, I'm picturing you like, as a child, like when you get a birthday present, do you just like unwrap it super quickly and just try to find out what it is before it even like figuring out who it's from, like, what it could mean? Because the storytelling, right? Like the proposed reg is essentially changing what? What is the word? What are the words that are being changed? Just for our listeners who are.
Yeah, it's shall to may.
Shall to may. So Tomer, when you're saying the judges have to do this thing, Noah, you're predicting that because it's going to go up to the Court of Appeals, just like Lasley did. What would you say would be the percentage of judges that will now use this new proposed regulation to deny cross? Like,
it's going to be 95%. I mean, you have judges primarily. Most judges are claimant friendly, and the only question is to what degree they're claimant friendly. You only have a handful that are really. I mean, you have. I would say no judges I would describe as carrier friendly. I would say at best you'd have neutral judges that actually, I wouldn't even call them neutral. I call them good judges where they actually are able to evaluate both sides and make a reasoned decision. But you're going to have 95% of judges that just say, no, you have no contrary medical. The statute gives me the discretion and you're not getting it. And they're not going to actually justify it. Or if they are going to justify it and go into substantive analysis of what's in the record and the medical reports that allows them to rely on it, it's going to be vague. It's going to be conclusory. It's not going to be legitimate analysis.
So let's talk about that, right? So if the 90 to 95% of the judges are going to deny timely requests for cross-examination, even when, as you brought up, claimants' doctors routinely issue medical reports that say total disability, yet have glaring holes elsewhere in that same report on the same date that gives evidence of a partial disability, that could be the contrary medical that we would typically use under Lasley, even if we didn't need it, or under 300.10c. That could be the thing that actually invokes the discretion. But from your point of view, you're saying that most judges are not going to do that. I believe you. I've been around long enough to say that, judges will definitely try to deny that. So then I want to bring back Tomer to what you said, is that if the judges didn't authorize the cross-examination, and I did like that you called them referees because I think that they hate that. But the statute actually does call them a referee. The carrier or the employer has the option to appeal, right? Withholding benefits during the pendency of the appeal, right? What do you think the board panel is going to do from the discretion point of view? Like, is it going to be a situation where they're just going to line up next to the judge and just say, yeah, the judge had discretion because you didn't have an IME?
I think that's kind of the fear. How is the board are they just gonna rubber stamp, the judge's decision to just waive your opportunity that you once had under Lasley or under 310C? It's kind of unsure in that way, but it's also just a board regulation, right? We have a third department case that's saying, no, this is how it's going to be done. So how they interplay is kind of curious and interesting to me. How is it going to play out ultimately when you have case law that's binding on the board versus one of those regulations that, it's going to have to make its way up, and we're going to have to get some more clarity on this issue, I feel like.
Right. So a couple of things. Again, because the Court of Appeals in Lasley was just interpreting a statute, they weren't creating the due process, saying it was a due process right. They leave it open, right? That's not definitive. It's like, okay, so we'll change. So the board says we'll change the statute, and now we don't need to deal with it. Like I
Right.
was saying before, it's going to have to go back up to the Court of Appeals and see if
Right.
it's an actual
Yeah.
due process right, and then they'll change everything. But as far as the board panel interpreting whether the judges use the discretion properly, the judges are going to be given a lot of leeway, and we've seen many board panel decisions where they mail it in, and the board panel can cherry pick facts from medical reports, significant
Absolutely.
findings where they can justify it. And at the end of the day, if the board panel doesn't side with you, what is your recourse anyway? You
Right.
can't stay awards based on the board panel decision. You take it to the full board, they're going to deny review, and you're going to, again, it will have to go up their department Court of Appeals to get that kind of, you get a definitive ruling on what you can do. At the same time, I don't think, when you talk about appealing, I want to differentiate between a couple of situations and requesting cross-examination. And when we bring up the matter of Lasley and this regulation, it's usually in the context of wanting to cross-examine a degree of disability opinion, rate of awards. But if you look at an issue, say a causal relationship issue, additional sites of injury, it's never brought up, right? Lasley is not brought up. The regulation is not brought up because it's almost taken as sacred that the carrier will be allowed to cross-examine a claimant's
Right, that's a
doctor
good point.
when there is. See, it's also, it makes why it's kind of contradictory what the board panel is doing here, because in a situation where the issue is causal relationship of additional sites of injury and we have no IME, 99.9% of the time, judges will allow us to cross-examine claimant's doctor on causal relationship. Why is the issue of causal relationship and relying on a medical report from a claimant's doctor any different from the issue of degree of disability and relying on a claimant's doctor?
It's a
Where
fantastic
in the
point.
one instance, they're going to just cite this regulation, Lasley, and the other doesn't even come up. It's
You would
almost
never
like
have to
a
cite
sacred
the
right.
regulation or
Absolutely
Lasley.
not. They would always allow it. But at the end of the day, it's like, is the claimant's doctor, are the reports reliable? Are we allowed to impeach their credibility or not? Now, if you have any common sense, you would say you should be allowed to cross-examine because we don't take it at face value. It's like, okay, you get the PFME finding at face value, fine. But beyond that, no, we get to cross-examine. So the fact that the board is making this distinction, and maybe they're not. And so the worst case scenario is you have claimants' attorneys that will start arguing that, hey, judge, look at the record here. Yeah, they don't have an IME, they want to cross-examine, but there's really nothing in the record.
Right, there's
to
no
say.
contrary medical
So
now.
they'll just argue.
You have your discretion. to
Exactly.
deny.
They'll argue the extreme the other way and say that, hey, they shouldn't be allowed to cross-examine. Let's establish all the sites, which we view as, wow, that's crazy. You take the extreme example and you really see what the board is doing. It's like they're not really thinking about it. That's one. The other point I wanted to make was, again, the context here is usually claimants' doctors are always filing reports finding 100% total disability, and we want to say, hey, that's ridiculous. Why are we paying it? Why are we shelling out all this money? If we cross-examine, because we have experience, we know in the majority of cases, when we cross-examine a claimant's doctor on degree of disability, they will almost always, it's definitely the majority. It's probably somewhere around 75, 80%. Claimant's doctors will say, when I was giving total disability, that's only from the prior job.
Right.
It's physically strenuous.
They can do a
Full-time,
light
regular
duty
duty.
job.
But as far as overall, yeah, they're markedly disabled, 75%, moderately disabled, because they can do sedentary work, they can do part-time work, they can do work with accommodations. We almost always get that concession. And you think about it and you're like, then why in heck was the carrier on the hook for paying at total rate when doctors are essentially filing fraudulent or false reports where they're giving 100% disability? So if the board wants to do this and say we're not allowed to cross, or not saying we're not allowed, but they're going to severely restrict the right to cross-examine, saying we don't have the absolute right to cross-examine claimants. I would say, at the same time, what you should do? And this is something I would say when the board was using C4 and C4.2 forms. Say if you wanted to make one change to save carriers and employers the most amount of money in the comp system, it would be to modify or amend the C4 and C4.2 forms, which were forms that were used. They're not used anymore because they regulated them out. It's just a CMS form and narratives. There was they would have to use those forms to submit as far as up-to-date medical evidence and degree of disability. And there would be a line in there about what's the temporary impairment. They'd always say 100%. Now, I would say if you wanted to make the one change to mitigate exposure on temporary indemnity, temporary awards would be to make it very clear to have a line about what is their disability in relation to their prior employment and what is their disability
overall,
as far as overall. Because there, you're bringing to their attention the doctors that, you can't just skate by and saying TTD, 100% disabled, and you do that. And that would change it. If you force doctors to put in their medical narratives that we're relying on, that claimants are relying on for their awards and degree of disability, to explain why they are this disabled. Is it from their prior job? What were their job duties that they can't do? What are their actual restrictions? If you put it, the proper burden on the doctors to justify it, then I can understand it. But because that's just not done, and we're just giving free reign to doctors to puke out these reports, just, copy and paste to temporary total disability, forcing carriers to pay lots and lots more money than they should, then you know what? Then we have a real problem here if you're going to not allow us to cross.
That's always what would... Go ahead, Tomer. Go ahead.
Yeah, I was just going to say that's an interesting proposal, honestly, to specify within the reports whether that's, related to the pre-injury job or is current or in relation to any sort of position, be it a sedentary light duty position, whatever it may be. The other thing that you noted earlier is that this proposed regulation requires judges to justify and give reason for why they're denying cross, right? So
yeah, and by the way, the case law is very clear. When judges make decisions, they're supposed to justify it. Like they have to, whatever decision they're making. So it's almost superfluous to say, hey, you know what, you're making a decision. You need to justify why you made the decision. But yeah.
Well, part of it is also like if those doctors said 100% from pre-accident job, 50% overall, that would actually stop the need for most depositions.
100%.
Because the only reason we're taking depositions on temporary degree of disability is, there is a matter of reducing the rate, but I don't think our clients are begging us to change the rate from 100 to 75, right? They're wanting us to litigate degree of disability so that we could raise labor market attachment and get a real leverage point in the case. And so we would actually probably not cross-examine.
And we would
many
save money.
treatments.
It would save lots of money. The system would be much more efficient. But the reason they're not doing that is obvious. The reason is money to claimants, money to doctors, money to claimants' firms. That's the reason for all of this stuff to begin with. That's what we're talking about. It is what it is.
So we have one. I cut you off, Tomer. What do you want to say?
No, I was just going to say, going back to having a judge requiring a judge to justify why they're denying cross. The thing I always like to harp on whenever there's a doctor who's really stuck on a total finding is go through the 96 guidelines and specify each point that they're missing in their report. So if a judge is going to deny my cross, I want him to explain how the 96 guidelines are still being met. So if there's no bowel, sexual, or urinary dysfunction, there's all these other criteria that are noted.
No assisted device, normal gait, no severe neurological
get off
deficits.
and on the exam table.
Exactly.
Then if you can't tell me that those are in there, then I'm appealing it. The issue then I'm wondering is that while it's on appeal, what do we do? Can we reduce it unilaterally? I don't know about that. It's not
right, because that's the problem also. It's like,
so
a few more things. I would say it's not just about raising labor market attachment. I think the TTD awards take on added significance because of SLU awards, where we want to get it off TTD because we don't want to avoid PHP, and also because of the 2017 reform of 15.3W credit against PPD awards, where the courts have said that doesn't apply to temporary total disability awards after 130 weeks. That's also significant as well. And then I forgot what I was actually going to say in response.
I guess he was asking, what do you decrease?
Exactly. Yeah. So the problem is when we're asking for cross-examination, we're not saying there's no disability.
Right.
We're saying that it's not total. So it's kind of funny because the recourse we would really get, the relief we would get from the board panel is to create a TR so that we can cross to determine what the actual degree is. We're not going to be able to suspend because we're not saying there's no disability. Now, if we said, my advice would be, if we're anticipating that the judge is not going to allow cross and we're going to have to appeal, we put in at the hearing, we have a position on what the degree of disability is based on the medical record, the clinical findings, and we justify saying, you know what, it really should be 75%. I would say most of the time it would be 75% unless there's something crazy, or 50%, and so the rate should be this. So then on appeal, we would reduce it. We would tell them reduce it to this rate that we were arguing for, and that's what would end up happening. But it's not going to be. See, we don't have that much power here. Where when we file an appeal, we could suspend. And it creates a lot more leverage. Here it's just like we wanted it to be TR so that we could reduce it. We just want to get it to 75%. So it's not going to be as much power there.
Yeah, but going back to Christian's point, though, a lot of times when we're litigating, let's say someone's 3 months, 4 months post-op, and they have all these reports for total, and we have we say, it's a 75%. Then we're just arguing over 75 versus total, when really the idea is that we just want to push it to labor market
Yeah.
and, suspend benefits that way. So like, even if we do say, nah, judge, if you look at the medicals, it's looking more like a marked disability. He says, no cross, I'm going to make it a total because you don't have an IME. We appeal it and keep it at 75 TR. Anyways, at that point, if I'm going to wait 12 months, I'm still going to get an IME in the interim, right?
Right,
100%. I know. So
what do you think about this argument then? If you look at a claimant's doctor's report and you say this is really rife with errors, and you make an argument to say that the claimant's awards are premised on their medical reports alone, right? Let's say they don't have a surgery. They just have 2 months of reports from the same doctor. And that same doctor has the boilerplate language, the blurbs, all the stuff that, is devoid of an actual physical examination. And you say, Judge, I want to hold awards in abeyance because these reports don't have any proof of a disability, right? Period. Because if you're saying, let's make an argument that it's 75% to get the reduction so that you can withhold it on appeal, what's stopping an employer carrier from making the argument that the claimant has no disability because these reports are a sham?
No, I would agree with that. I mean, sometimes, if a doctor doesn't sign a report, if a doctor doesn't include certain things in a report, you can certainly make the argument that it's insufficient basis. That's an insufficient basis to make awards. I would 100% make that argument. I was also thinking when you were talking, it's like, what's to say that, hey, this regulation gives the judges more discretion? Say, okay, judge, you have a lot of discretion here. Why don't you review it? Okay, and why don't you make an actual finding that there's a partial disability here, judge?
Yeah,
why don't you look at the record and you just if you can't justify a total disability, judge, like they want you to justify it, then just say that there's a partial disability, make awards at partial, and say that that's what supports. Why? What's to stop you from doing that? Fluff, pump up the judge and say, hey, you got the discretion. Look at the record. You can't justify a total, so there's a partial.
That's what I say when judges want to not authorize cross. If it's like, let's say 100 versus 75 and they get so angry that you're litigating 100 versus 75. And I actually point out to the judges that the reason we have to do these depositions is because the claimant's doctors don't actually issue truthful reports, right? So you're making that argument. Like I would love for the doctor to just admit what he's going to say in a month, that the claimant can do sedentary work. So let's just keep it at 75 TP. Let's raise LMA. And judge, you don't have to read like 40, 50 pages of transcripts. Like it's a ridiculous notion that you're pointing out that it's done to, feed the wheel for the other side because, like I said, like a lot of these depositions don't need to be done if the claimant's doctors, issued truthful reports.
Yeah, I agree.
Okay. So, let's get to, Tomer, you wanted to talk about a different part of the regulations because, the most important part of these regulations have to do with these cross-examination issues. But let's try and tie this all together and really show why the board is not our Valentine this year. Right?
As opposed to all the previous years.
That's true. Maybe just 2017 and 2007.
And 2017, they were.
2 years that they were our Valentine. You have something that's kind of like sticking in your craw about other parts of these regulations.
Yeah. There's another part I think isn't discussed as much, but whenever we're going in for a hearing and we're requesting depositions, judge will make a determination to depose all the relevant doctors, including IME doctors. But it's really an opportunity for the parties to cross-examine those doctors that the party themselves want. Obviously, I have no interest in subjecting my IME to cross-examination. So in my mind, if the claimant's interested in doing it, they have to initiate. They have to put in the effort. They should subpoena, obviously, our doctors, right? It shouldn't be our burden to open our doctor up, right? If you want to take credibility issues with our IME, so be it. That's your right. But I shouldn't have to facilitate so much beyond, being courteous and accommodating with finding dates. But this new regulation, the proposed regulation, is putting all the emphasis on carriers to spearhead the deposition of their own IME. I had a recent case for a law judge where, claimant's counsel made no effort to depose our doctor in the time frame allotted. And then when we returned back on the record, I argued that they should be precluded from cross-examining our doctor. But this law judge will remain nameless. no, she denied my opportunity, or denied my argument, and just extended the period for cross-examination, delaying everything, and still, we just see claimants' counsel kind of putting their hands up, but this new regulation is forcing us to do their job, basically.
I mean, as it is, the carriers are already paying the IME doctors. The carriers are paying the claimants' doctors, and there's more claimants' doctors as opposed, so they're bearing those costs. With the IMEs, the carrier's already paying the IME fee, deposition fee. The only thing they were asking opposing counsel, claimants' counsel to do is, if you want it, okay, at least make an effort with us to schedule, or you issue the subpoena yourself. That would be the only cost. You have to subpoena the doctor, okay? Even if they set up, and then maybe they pay the stenographer, but maybe the carrier would still pay for the stenographer. That's the only thing they would have to do. It's not that much to ask attorneys, a firm, right, that practices law.
For profit.
That practices law to send subpoenas and depose. Like, it's ridiculous that enough claimants firms clearly complained to the board that, oh my gosh, it's so annoying that we need to send emails or phone calls to IME vendors and these doctors to help schedule their depositions and then send the time of subpoena. I mean, it's ridiculous. And yet the board acquiesced and is putting the burden on carriers and employers again to set everything up. And so again, we lose out on the avenue of defense where, hey, claimants counsel didn't make the effort. They've waived their right to cross-examine. Now, again, it's just back on the carriers. In addition, they say if the carriers now don't pay within 45 days, you don't have to pay $450 to the doctors. You have to pay $700. Yeah. That's right. That's another part they slipped in there. I will say what the only it seems like efficient smart change was they're going to have a form for deposition extension requests. Whereas before we had to, make this whole filing with the attorney affirmation and correspondence. Yeah, I think so. You can just submit a form, make it a lot easier. But yeah, I mean, does the board understand that a lot of these doctors are their depositions take 12 minutes?
Right.
$450. $450 for like 15, 20 minutes.
It's a
like
great
on average.
rate.
And then what? They don't pay 45 days. You get $700.
Yeah, these regulations, basically what I'm seeing is that this is just costing more money for carriers. Any way you cut it, there's going to be a more heavier reliance on getting IMEs for not only causal relationship, but, for fighting degree of disability. Obviously, what Noah's talking about right now, more cost to the carrier. Just the whole thing, subpoenaing our own IME, just making sure those are coordinated from our own doing. This seems like a punishing regulation from the board to the carriers, and with really no credit to what is already, with 310C in the board file, or with 310C as a regulation, and Lasley versus Wegmans, and everything kind of being thrown out in this one proposed 2-page, 3-page edit from the board. It seems very frustrating.
Well, it's a situation that's going to, it's not going to bear its fruit until once the regulations change, if they do, right? So, like we heard earlier this month, send in the comments to all the listeners here that are stakeholders on the right side of truth, right? Send in the comments to the state. Note that they will be made public, but voice your concerns about how this really affects the due process rights of employers and carriers in the state of New York. What do you guys think also about records reviews, right? Sometimes you can't get an IME for timing, for examination purposes. I
think it's interesting. It's an interesting point you make. Maybe just get a record review
just to get the cross.
It's sort of ridiculous. It's sort of ridiculous. It's just like, it's sort of ridiculous that we would have to go to those lengths and pay for a records review when we basically just want a doctor to say, hey, look at the record and just tell the judge essentially why there's no justification for a total disability assessment. Right. What's interesting also is if you look at the way the board describes the regulatory impact statement to these changes, the intent of the regulatory change to 310C, right, and what Lasley did, and just emphasizing what the statute said is it would allow the judge to deny cross-examination when the denial is non-prejudicial, and cross-examination would be duplicative, superfluous, or dilatory. So you tell me, how is it non-prejudicial to force carriers to pay total disability awards when a doctor is not actually justifying the total disability assessment?
It's never going to be non-prejudicial, right? Exactly. You're telling me I can't raise labor market attachment. You're telling me I'm going to increase my opportunity for PHP exposure. You're telling me I'm going to decrease my opportunity for a 15.3W credit. It's always going to be prejudicial for a carrier to pay someone as if they can't work a single job in the entire world. You know, Tomer, you brought up the 1996 guidelines. That is 30 years ago, right? 30 years ago that we have this criteria for what a total disability is. And yet all the changes that have been made since then have been to not really get to the matter of what's being discussed. It's just to kind of enforce more costs on one side.
Yeah,
right.
I agree. If they really wanted to, as they say, allow judges when there is sufficient evidence in the file to do so, resolve matters without adjournment and delay, what they would actually focus on is that sufficient evidence aspect and forcing doctors and claimants to produce reports and evidence that actually is sufficient to justify the awards. And when they're not doing, they're just ignoring that and giving wide discretion to judges to award claimants whatever they want.
Well, you know, Noah, if you ever run for any kind of public office, we know that referendum number 1 will be an extra line on the CMS 1500 for percentage of disability from overall versus pre-accident job.
Yeah, I would put in something that if a doctor does not justify or articulate the actual reason for a total disability opinion, then it's not sufficient.
Right.
Yeah.
It's very simple. They could have just done that, like you mentioned before. If they had just done that, that would be the massive saver.
Oh my God. Yeah.
Expedience, efficiency.
You want more cases
in the
marked
system.
NFA?
You want to avoid depositions? That's
Do that.
what you would do. But they don't want to. They're not doing it to avoid depositions. They're doing it to avoid chances of claimants losing out and firms losing out on more awards. That's what they're.
Yeah, you know,
for.
to that point too. You know, when I'm crossing doctors who continue to find total, and I ask if it's with respect to any sort of position I claim it's pre-injury, and then I'd say 8 times out of 10, 7 times out of 10, they'll say no, it's just the pre-injury work. You know, as a construction worker, as a factory worker, something very laborious. And then I usually follow up with, is that your common practice?
The common practice
To just file reports
right.
saying 100% total disability without actually basically lying about the disability without
We're
saying.
going to destroy your credibility while also getting the concession.
Yeah.
Yeah. I think
So, I mean, from there, like I'd want to argue, from a judge, if the judge is going to deny me a cross from a doctor who's already testified previously that their practice is, no, it's always pre-injury. It's always pre-injury. So I want to just, that's my thumb on the scale, I think. When I get denied cross, it's like, well, you're going to buy this total finding from a doctor who's already told you that they don't know the standard? They don't know what they're doing, Judge.
Yeah, I wonder if actually in cases where you have doctors, because we see a lot of the same doctors in a lot of these cases, right? The comp doctors, the comp mills, these offices.
Right.
I wonder if you brought in testimony from doctors. Yeah, you have the same doctors where they've testified that when they say 100% on their report is only pre-injury, if you bring them from other cases, right, redacting claimants' names, and you say, hey, Judge, like, look, we actually had this doctor, and he says when he's giving 100% on his reports, it's actually only from the pre-injury job. We should be allowed to do that then. Yeah,
it's a very similar scenario to what I had this morning. I deposed a claimant's doctor who had this blurb in his reports saying that the claimant was temporarily totally disabled from any gainful employment, can't do sedentary work, can't use a telephone switchboard, can't sit or stand at will, can't do anything. Even if given the option to, take as many breaks as possible. And so I know I've seen that blurb in other reports. And I actually said, doctor, this is a blurb that you've used in reports from other cases, correct? Because I want to focus on this actual claim and what this claimant can do. And the doctor got so angry because, of course, his reputation's at stake. And he says, counselor, that's a medical opinion. And I was like, well, everything you're saying is a medical opinion, right? It's just, I think we do need to push back more on this kind of thing. If the board is going to use this administrative and regulatory power to change case law precedent, binding case law precedent, the onus is on the employers and carriers to not rest, to keep fighting, making sure that the good arguments are made, finding that needle in the haystack. So I want to thank you guys for coming on the show today. Very enjoyable content for our listeners. Episode 101 got a little bit of a 301 feel, to be honest. But for Tomer Lehr and Noah Pollack, my name is Christian Cison, reminding you to defend from day one.